When seeking full or limited guardianship, pro se, or self-representation in court without being represented by an attorney is possible. This video will outline the process and introduce you to terms and resources you may find helpful. Petitioner: person seeking guardianship authority for an alleged incapacitated individual. Protected person, respondent, or person needing protection is the individual for whom you are seeking guardianship. Pro bono, professional work done at no cost, providing services to those who cannot afford them. Full or plenary guardianship covers all areas of decision-making, including financial, medical, residential, education or training, healthcare, nutrition, personal care, and estate. Guardianship can be modified at any time. Limited guardianship applies only to those areas specified in the guardianship order. The individual retains all other decision-making rights. Emergency guardianship is an emergency situation. Guardianship can be granted for a period of up to 30 days. For more information on types of guardianship and whether guardianship is the right option for your loved one, or if an alternative to guardianship is more appropriate, please refer to the Utah Parent Center's guardianship book and videos. Pro Se Checklist. The following is a Pro Se checklist. This information will help you understand the Pro Se process. Number 1. You can begin the guardianship paperwork online no earlier than when your child turns 17.5 years old. You may also request a hearing date prior to their 18th birthday. It's possible for the guardianship to become effective on their 18th birthday. Number 2, you will want to gather personal information and documents, including social security numbers, driver's license numbers, and addresses of the person applying for guardianship and for the protected person. Number 3, go to the website utahcourts.gov. Click on Representing Yourself, which is located midway down the page. Scroll down and click the OCAP tab. Create an account with a username and password. Number 4, from the list of Start New Interview options, on the left-hand side of the screen, select Guardianship of an Adult Child under the tab heading Guardianship and Conservatorship if you are the biological or adoptive parent. If you are a sibling or a type of caregiver seeking guardianship, select the Guardianship of an Adult interview. Be sure to not select the Conservatorship interview for guardianship. The conservator interview is used with regard to property and estate. You can find more detailed information on conservatorship in the Guardianship Handbook. Number 5, complete the information requested on the form. By answering these questions, the online court assistance program will generate the needed documents for your court case. If you are not sure how to complete a section of the forms, you can select Save and Exit and return to the forms at a later time. Your information will be saved for 180 days from your last login date. You will want to read through all of the instructions carefully on needing an attorney for the child. You will only need an attorney if the statements are not true. Number 6. When you have completed the interview, select View Documents. Your court documents will be prepared with the information you have entered, along with instructions for submitting them to the district court. Number 7. Review the documents and make sure the information is correct. If the information is accurate, you will have a few options. You may download the documents to your computer and email them to the appropriate court email, which you can find by going to this link. Or you can print 2 copies, one for the court and one for yourself. You will want to sign and date all of the documents where indicated before you send or take them to the court. Number 8. There may be additional necessary documents you will want to send to the court along with the court paperwork. There is not a specific list of documents or reports because each person is different, and it will be up to the judge to determine whether the evidence provided is sufficient. For example, judges like to see a doctor's letter, neuropsych evaluation, clinician evaluation, witness affidavit, latest IEP, and/or the summary of performance from the school to determine mental capacity. And the important thing is to remember clear and convincing evidence to show incapacity and the need for the level of authority the parent is requesting. Obtain a report from a physician or psychologist on their letterhead that indicates the specific description of the diagnosis and the description of the incapacitated person's functional impairments. List what tasks they can do on their own or with assistance, what medications are taken, and a description of what they are used for. Describe the prognosis for improvement and recommendations for appropriate rehabilitation. The report should state the need for guardianship, and it needs to be dated within the 6 months prior to filing for guardianship. Number 9. In order to be appointed as a guardian or conservator, you must learn about the responsibilities of a guardian or conservator and tell the court you understand those responsibilities. You will need to take the following test. Be sure to complete the declaration of completion of testing at the end of the exam and file it with the court with the rest of your paperwork. Number 10. You will then need to contact the district court clerk closest to where the protected person you are filing guardianship for lives in order to schedule a hearing date. Your district court will have timeline information for this process. Number 11. There is a small fee for using the Utah Courts or OCAP website to generate the forms to file your petition. When you file your petition with the county court, you are also charged a minimal filing fee. These fees are listed on your OCAP forms. If you are unable to pay the fees, you can apply for a fee waiver. The fee waiver application is on the OCAP website. Number 12. You will be asked to serve your youth and possibly other interested parties the notice of hearing once you have a hearing date. This is often confusing for those who have not had experience with the legal process. Serving is merely a way of informing those who need to appear in court or who have a significant interest in the action. To serve papers, have a third party or an adult who is not the person seeking guardianship give the youth the notice of hearing paper and have it explain to the youth what the paper means. A third party can be a grandparent, neighbor, or other trusted adult. Make note of the date and the time the youth is served. If it seems strange that you would serve papers on someone who has limited capacity, consider that this is simply a protective legal process. Number 13. Attend the hearing either in person or virtually and have your youth attend with you. Some district courts are holding virtual hearings, so be sure to ask the court clerk what they prefer. If attending in person, remember the court hears multiple cases and the court can be crowded. Be prepared to wait if needed. Your child is expected to attend the hearing unless there is a clear and convincing evidence from a physician of 4th stage Alzheimer's, extended coma, an intellectual disability with an IQ of less than 25, or a report from a court visitor. If guardianship is granted, you will be given a letter of guardianship stating you are the legal guardian, along with a finding of facts and conclusions of law, and an order of guardianship that will outline the areas of guardianship, whether that's full or limited. Number 14. Before you leave the court, be sure to ask how you can obtain several copies of your paperwork. You will need several copies as you apply for adult services and to show medical providers and financial service providers. If ever in need, you can go back to the court for additional copies. What to do after guardianship is complete? As soon as possible after guardianship is awarded, guardians should notify the people and entities you will be working with and interested persons. To notify individuals that you are guardian, you should inform the person or entity you have been appointed, give each copy of your letter of guardianship and an address, email address, and telephone number at which you can be reached. Ask the person or entity whether they recognize your authority or if they need something else. Examples of individuals who may need to be notified are the protected person's spouse, children, parents, or other family members who were involved in the case. Additional examples include the protected person's employer, the administrator or manager of the protected person's residential facility, the protected person's healthcare providers and caregivers, the protected person's education and training providers, banks, savings and loans, credit unions, or other financial institutions where the protected person has savings or checking accounts or credit or debit cards, stockbrokers and financial advisors, companies in which the protected person owns stock, insurance agents, government agencies such as the Social Security Administration, Veterans Administration, and Workers' Compensation Fund, from which the protected person receives payments, pension plan administrators, people who owe the protected person money or to whom the protected person owes money, the county recorder in every county in which the protected person owns land, the post office if you want to change the protected person's mailing address, and anyone involved in a lawsuit by or against the protected person, any person the court has named in the order of appointment whom the guardian must notify of any significant health care or treatment received by the protected person. Resources. The following resources are available to assist you. The Guardianship Signature Program is a program under which attorneys volunteer to represent the person needing protection or the respondent who need an attorney and do not have the means to obtain one. If needed, you can submit a request to appoint an attorney and one can be requested. The judge will wait 60 days for a volunteer attorney to respond before setting a hearing date. If no one has responded within the 60-day time period, you can either find an attorney to represent the defendant or the judge can send a court visitor to see that the rights of the defendant are being met. There is a sliding fee scale that can apply. Utah statute. The state statute surrounding guardianship can be found on the state legislature's website. Utah Law Library. You can visit the law library and utilize their public computer to fill out paperwork on the Utah Court's website. However, they are not attorneys and are unavailable to give legal advice. The law library is located at 450 South State Street in Salt Lake City. Their phone number is 801-238-7990, and they are open Monday through Friday from 9 to 4:30 p.m. If you have questions, reach out to the Utah Parent Center, and a parent consultant will be happy to assist you.